Battery by bodily waste.
I mean, that's probably like
Pulled an R. Kelly?
Maybe, or maybe he pulled a chimpanzee and he flung poop at
he
somebody.
probably flung poop. We are the Armed Attorneys. Today we are talking about a case out of the Northern District of Indiana that challenges 18 U.S.C. 922 G1. That's our general prohibition on felons possessing firearms. Now, is this the case to unwind that provision? Do we have the right facts? That's what we're going to be talking about today. But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is sponsored by our friends over at Sonoran Desert Institute. With more than 350 million firearms in the U.S., it's never been a better time to learn how to be a gunsmith. Sonoran Desert Institute offers online firearms technology education with hands-on labs and materials shipped right to your door.
Course topics range from AR-10, AR-15, or 1911 armorer options to shooting sports management, ballistics, gunsmithing, and more. Get your education and turn your passion for firearms into a successful career.
Visit sdi.edu or call 480-999-4767 to get started. Tell them the Armed Attorney sent you or use our link in the description, sdi.edu/armed attorneys. So we're talking about the United States versus Dietrich L. Cummings. Now, this case, if you want to look it up, is 122 CR 51HAB. It's an 8-count indictment. And what kind of case are we dealing with?
Well, apparently, Mr. Cummings decided to sell drugs and a firearm to an undercover officer. And since Mr. Cummings has a very extensive felony record, they decided to go ahead and prosecute him in federal court for this violation of 18 U.S.C. 922 G1 that says that you cannot possess a firearm if you have been convicted of an offense where the punishment is more than a year in jail. Of course, this means most felonies. It does specifically exclude, weirdly enough, antitrust crimes and state misdemeanors that may have punishment over a year. So they, instead of selling felon, they just try to keep it at the range of punishments.
So this is kind of unique, and that's count 7 of this indictment. But what makes this case unique is this is one of our first challenges that we've seen to this provision of the United States Code post New York State Rifle and Pistol Association v. Bruin. Now, we've seen other parts of this exact law struck down. Think about transfers between misdemeanor crimes of domestic violence. Think about protective orders. We've seen these across the United States. And so a lot of scholars have been speculating, hey, this might be a place ripe for unconstitutionality and it needs to be challenged. Now, as we know, just by brief overview, our standard in New York State Rifle and Pistol Association v. Bruin, it's a one-step test looking at the text of the Second Amendment. If it's not clear based on its face, we look at the history and tradition of firearms regulations at the time that the amendment was adopted, 1791, and we look at, is that something that the government would regulate at that time? And historically, is that something we'd look at, Edwin?
This is actually in a bigger picture. Every single gun law is going to be challenged under Bruin. So you get a new standard, and we're actually in a very unique time where we're seeing the development of constitutional law. So, lawyers and judicial scholars 50 years down the road will be looking at this time period where every single firearm is going to be scrutinized by the courts under this new Bruin standard. And of course, this is the one that really kind of draws the most attention. When you talk about prohibited persons, felons are always the very first people mentioned. You say, well, what group of people should be prohibited? Felons are the very first one. And so this is something that we knew was going to happen, where a felon was going to challenge this prohibition. It's just kind of bad that it happened to be this felon.
Yeah, and I think that there's going to be good arguments, and we have this court's order. Essentially, the defendant in this case, Mr. Cummings, asked the court to dismiss the regulation. There's kind of a silly quote. I'm going to have you read it in a second. But asked the court to dismiss this case as it being unconstitutional as applied to him. Now, there may be a case in the future where it might be appropriate, but I don't think that the court agrees with him in this case.
Yeah, and just as a little aside, just to tell our folks, whenever you're attacking a law on constitutional grounds, you have two forms of attack. You can either attack it on its face or as applied. And I don't think an on its face challenge is going to be very productive on challenging this particular law. And so these are going to be a lot of felons that are going to have as applied challenges, saying their specific case should be treated different than your normal felon in possession. So, yeah, the quote that you mentioned earlier was the court said, defendant has chosen the first step as the hill he will die on, arguing that he is one of the people whose right to bear arms is protected by the Second Amendment, regardless of his extensive criminal history. And I thought that was kind of interesting because, to choose the language, the hill he will die on,
Right.
in a firearms case. And also legally, you kind of want your first step to be dismissal of the
Yeah.
case.
I thought it was a little silly for two reasons. One, because of his extensive criminal history, and we got to talk about that next. But also that the court is just kind of, why are you challenged? Like, thou doth protest too much,
Well, yes, and of course, legally as the lawyer, you're going to put your best foot forward. You're not
Yeah.
going to say, "Hey, judge, here are 5 arguments. My first 4 are very silly, and you should not pay attention to them. But that 5th one, that's going to get you."
Yeah.
No, you want to get the case dismissed on your first hill.
But the court goes back and it says, and this is out of the opinion in Bruin talking about, they mention expressly felons, they mention expressly the mentally ill, but the court in this case is citing an 1866 South Carolina law about people who are disruptive or may cause a public disturbance as not being or as being those legitimately deprived of the Second Amendment for purposes of regulating it. 1866, is that the right time we need to be looking at?
No, it is not. 1866, especially 1866 South Carolina, that was during Reconstruction. That was clearly a far different time than 1791 when the Second Amendment was written. And so I think that this judge has kind of fallen into the mistake of looking at the wrong, looking in the wrong context, looking in the wrong time period. Of course, this judge attempted to correct herself because later on she talks about the vast number of colonial laws that prohibited felons from possessing weapons. Of course, she does not help us because she does not give us a single cite to
Yes.
what these vast laws are.
Yeah, she said there's this long history and tradition of colonial firearms restrictions, and then there's citation missing.
She pulled one law out of the books. It's not a colonial law. It was a Reconstruction law, not really applicable, I think, to the historical analysis that's needed here.
Yeah, but I think the bigger picture here is we need the right kind of as applied challenge, when looking at this. Because right now we have a one size fits all solution to, felon in possession. And I mean, there's a lot of felonies on the books that you would think, or probably leave you scratching your head saying, should you lose your right to keep and bear arms forever because you forged an inspection sticker on your car? Maybe that's the kind of case that we look at, but we have kind of a long criminal history here, and this person doesn't seem to be our ideal test case. Just going through his history, he has a conviction for felony battery, battery with bodily waste, battery on a correctional officer, and aggravated battery. I mean, that's spread out over half a decade. So I mean, he seems to be kind of the person when we say we don't want violent felons to have guns. He seems like that kind of character.
Yeah, and you just seem to just sail right over obviously the most abusive of his felonies, battery by bodily waste. Ew.
Well, you can use your imagination on that one, but I think it goes back to we need the right case to challenge this. We have felony window tint violations in some parts of the states. We have, all kinds of forgeries and things that maybe aren't indicative that you're a good person, but should you lose your right of self-defense or your fundamental right to keep and bear arms over that stuff? I'm going to be interested to see how that plays out.
I've actually defended an individual charged with felony counterfeiting government document. It was an inspection sticker. And this was just some dude who wanted to save a few bucks on his inspection sticker. I mean, this is
Did he turn a 6 into an 8? What did he do?
I think that maybe his actual license plate number didn't match the number on the inspection sticker.
No.
And so, I mean, that's what got him caught. But this is an example of a law that we say mala prohibitum, which means that it's not a moral law. It's not a violent law. It's just a law where the government says, hey, we have these rules and you violate them. This one just happens to be a felony. And yeah, if somebody's convicted of that, lose their Second Amendment rights forever and ever and ever. We need a person in that category. And the thing about it, since the federal government picks and chooses who they charge with this crime, we may never get that.
Yeah. No, I'm interested to see what you folks have to say. Should we have a one size fits all solution for felon in possession of a firearm? Should we discern? Should we look at, hey, this person's a repeat violent offender? Hey, this person did something stupid when they're 18 and forged a document. Should we treat those two people the same? I'm interested to see what y'all have to say, but we hope you enjoy this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti 2A algorithm by sharing this video. And until next time, we're the armed deterrents.